Good afternoon, everyone. It's my privilege to welcome you all to the next panel discussion today, Daksha Conclave. The panel is on something contemporary, from the amendments to the specific relief act. As much as the amendment is a bit old, probably the time has come up for a good assessment and a review. It was with a lot of expectation that we look forward to the amendments to the enforcement of contracts on the way in a solid state. There are, of course, complex reasons for it, but one of the elements was the structure of the law itself. And so the Specific Relief Act was amended with a lot of change in principles. We've really overturned principles that stood for close to 100 years, but for good reasons. And now it's my privilege to welcome this panel to have a discussion about these amendments. Mr. Mihir Nanavidekar has agreed to chair the session. He is a lawyer at Bombay. He graduated with a University Prize in Law and Economics from the NLSIU Bangalore. And he currently pursues tax litigation in commercial arbitration. He's appeared as the lead counsel in a number of reported tax judgments of the Bombay High Court, and he's also been appointed as an amicus in a number of important tax cases by the Bombay High Court. He also advises clients on treaty-related and transfer pricing matters. He's also very active as a writer. A number of his articles have been published in reputed peer-reviewed journals. He's also taught at the National Law School of India, University Bangalore. He regularly accepts appointments as arbitrators in commercial disputes. Thank you, Mihir, for agreeing to moderate this session. Over to you, Mahesh.
Thank you very much, Mahesh. I'm delighted to be here, and I hope I am audible to everybody. I'm also delighted today that we have a wonderful panel of very experienced panelists. We have Sri Raghuram P, senior advocate and an expert in commercial law. We have Mr. Amit Kapoor, who's a managing partner at J. Sagar Associates and a renowned expert on infrastructural laws and regulatory litigation. And we have Professor Nihima Bhatbade, who was a member of the expert committee which was constituted prior to the amendments coming into force. And I look forward to hearing her thoughts on whether the recommendations of the expert committee have adequately found their way into the Act or not. So, without much ado, I would like to begin the session. And to begin, I would like to invite the fellows and students at Daksha to give us a brief overview of the amendments so that we have a good base to start off with and we can go deeper on with each of the individual speakers. So may I request the fellows at Daksha to just introduce us to the provisions of the Act and get things started. Thank you.
So firstly, I'll talk about the need for the amendment and why it was brought about. Then I'll talk about the scenarios that were earlier and what it has changed to after the Amendment Act. Post which I'll talk about a few key changes brought about by the Act. After which my friend Sahil will talk about the provision regarding substituted performance under Section 20. After which my friend Anirudh will talk about public utility contracts and the nuances engaged with them. And he'll go on to conclude the presentation. So quickly starting for the need for the amendments. So now I will run you through about the underlying circumstances as to why this Amendment Act was brought about. The Specific Relief Act was enacted in the year 1963, which is precisely 58 years to the previous to the current scenario. So the nature of commercial contracts was very different back then as it is from today. In today's world, the parties require a speedy and a strong enforcement mechanism. Earlier, the parties used to breach the contract and get away by paying a compensation. This led to uncertainty and lack of execution of contracts, which costed India big time in the ease of doing business index. Also, there was a need for expert assistance in contracts of technical and commercial nature, and this was not present in the previous statute. Also, there's the customary norm of substituted performance, whereby a third party or an agent of the plaintiff undertakes the execution of the contract, and the defendant pays back the plaintiff in their rights of their substituted performance. This was a customary practice, but it was not having a legislative backing. And lastly, the resolution took a lot of time. The suits for disposal of the specific relief took a lot of time, which rendered the very objective of the act fruitless. So these are the reasons why the amendment was brought about. So now we look how the scenario has changed currently. So earlier, when there was a breach of contract, the court used to grant compensation as a first relief to the parties. If the parties wanted a plea of specific performance, they had to prove to the court why the compensation was an inadequate relief. This was known as the inadequacy test. But now that has been done away with by the current amendment. After the current amendment, if there is a breach of contract, the court will compulsory grant a plea of specific performance. If if it is not feasible for the courts to grant a plea of specific performance, they'll grant a plea of substituted performance, whereby the third parties will perform the acts of the defendant, and the plaintiff would have the right to get the damages from the to collect the monies from the defendant regarding the substituted performance. So this is a welcome change because this will give some certainty to the contracts, and it will be better for the ease of doing business index. So now let's see what has changed in the specific performance provision. So the section 10 was amended to ensure that parties uphold their contractual obligations. Earlier, they just used to breach the contract and get away with a compensation. Now, specific performance is now the norm, and the damage is the exception. But however, this relief is subject to section 11(2), which is if this section is regarding to trust. So if the trustee acts ultra vires to his powers, then the relief of specific performance would not be granted. Section 14 talks about contracts which are not specifically enforceable, and section 16 talks about personal bars to specific performance. So overall, the discretion of the court has been pretty much done away with. The section 10 and 11 of the Act have made it compulsory for the courts to grant the specific performance wherever the case is made. This can be seen by the legislative intent, whereby in section 11, the words contract made in the discretion of the court have been changed by contract shall. This gives us the legislative intent of the parliament, which tells us that the specific performance should be the norm as to the exception, which was the case earlier. So now I'll talk about some key changes which were brought about by the 2018 Amendment Act. Earlier, the third parties who got their property dispossessed had no right under the specific relief act. However, now under section 6(1), this amendment has been made whereby third parties have a right and have an opportunity to claim specific performance under this act. As I spoke about earlier, section 10 and 11 were amended so that specific performance becomes a norm and the power of the court and the discretion of the court is reduced. After that, now in today's world where there's a desperate need of expert appointments in trials of specific performance, now we have an explicit clause under section 14A whereby an expert appointment would be granted. After that, there was a lacuna in the act whereby there was silence of the law with regard to the amalgamated LLPs. Now there is a explicit recognition of LLPs under this act under section 15FA. After that, in section 16, there was a specific requirement earlier that the plaintiff makes an explicit avowment in his pleadings regarding his readiness and willingness to prove that he was ready to perform his side of the contract. This was used as a technical ground by the defendants so as to not perform the contract. However, looking at that, the parliament removed the provision remove the words avowment from the section, and now the parties only have to prove their readiness and willingness, and they don't have to specifically avow that in their plaint. Next is substituted performance under section 20 and infrastructure projects in section 20A, which will be dealt later by Sahil and Anirudh respectively in their presentation. After that, subsequently in section 20B, there is an establishment of a special code which will look into such infrastructure projects which are being talked about in section 20A. And lastly, for expedited disposal of suits, there has been a time limit established of 1 year, which will be condoned by which will be condoned by 6 more months with reasons in writing. This will help the parties get their specific performance in a expedited manner, which is the need of the hour for the commercial contract. Now, my friend Sahil will take over with regard to substituted performance of the contract.
Uh, Thank you, Harsh. Good afternoon, everyone. My name is Sahil Bhatia, and today I'll talk about the substituted performance of contract. Substituted performance, as the name suggests, is a remedy in which the promisee has the right to get the performance of his contract from a third party and claim the amount concerned from the promisor. It has substituted performance has benefits such as to place the promisee in the same place as if the contract has been performed. Moreover, it also helps in achieving the ultimate goals which have been discussed above, that is to improve the India's rank in ease of doing business. Now, for the purpose of present presentation, I'll divide the I'll divide the topic of substituted performance into 4 segments. That is, I'll discuss about the pre-amendment norms relating to substituted performance. I'll talk about the recommendation of expert committee. Then I'll talk about section 20 as implemented. And at last, I'll do a critical evaluation of section 20. Now, coming to pre-amendment norms. Prior to the Amendment Act of 2018, substituted performance was already present in the common law norms of India. However, it was not recognized as a substantive law remedy. It has its foundation in clauses known as risk purchase clause or risk and cost clauses. These were the contractual clauses which gave the promisee a right to get the substituted performance from the promisor. However, the enforcement of these clauses were limited, and they were guided by the principles of forcibility and mitigation. And taking into consideration that a party does not have the right to substituted performance in case they do not have a clause in their contract. Moreover, to taking into consideration the goals which we have discussed above, the expert committee discussed about the norms of substituted performance, and they recommended that substituted performance should be recognized as a substantive law remedy. They discussed that if a promisee has the right to claim the has the right to claim the amount spent in the substituted performance, he will prefer to do so. However, they also anticipated that the promisee may take undue advantage of this right to substituted performance, and he may create a burden for the promisor, as they stipulated certain obligations which promisee must fulfill in order to get the benefit of substituted performance. Now, there are 4 to 5 obligations which the expert committee recommended should be fulfilled by the promisee. I'll not deal with all the obligations. I'll deal with the obligation relating to notice along with cost. So, expert committee report said that in order to claim the substituted performance, the promisee must send a notice to the promisor stating the cost which will be incurred in case there is a substituted performance. Now they anticipated that if the promisee is sending a notice to the promisor, it will nudge the promisor to perform the contract from his part, and it will also give both the parties an opportunity to renegotiate their contract. Apart from this notice obligation, they also stipulated that that the plaintiff should perform the contract, like there should be a performance by third party. The promisee must prove the breach of contract, and he must also prove the reasonableness of the amount claimed. Now, through the Specific Relief Amendment Act 2018, under Section 20, the Parliament, though not entirely taking into consideration the recommendation of expert committee report, has recognized the right of substituted performance, and they have said under Section 20, subclause 1, that if there is a failure on the part of promisor to perform the contract, the promisee shall have the right to claim the substituted performance through the third party or through its own agency. So basically, in order to trigger the remedy of substituted performance, 2 essentials should be fulfilled. That is, there must be a failure on the part of promisor, that is, there must be a breach, and the promisee must avail this remedy of substituted performance through the third party or its own agency. However, under Section 20, subclause 2, they have stipulated a condition, that is, they said that the promisee must send a 30 days advance notice to the promisor for availing this right of substituted performance. Now, when we go to the critical evaluation of this particular provision, as I said that the recommendation of expert committee have not been taken into consideration entirely. So there is a non-implementation of the expert committee report. So for example, the committee in its report recommended that the promisee must send a notice to the promisor, and in that notice, the promisee must stipulate the cost which will be incurred in case of substituted performance. However, in in present section 20, we do not have any such cost obligation. The promisee is only required to send a 30 days notice, is not required to give any sort of cost which will be incurred in case of substituted performance. The second issue which arises is relates to the time period within which substituted performance can be availed. So the provision of section 20 are silent on this aspect. So the question arises, what if there is a breach of contract in the year 2020 and promisee comes and claim the remedy of substituted performance in the year 2022 when the market conditions have changed? So can he do so? And if he can, isn't it against the rights of promisor? The third issue or lacuna which arises relates to the short-term and urgency cases. So the committee, the parliament under section 20 said that the promisee is required to give a 30 days notice to the promisor. But my question is, what if the nature of contract is a short-term contract? What if the entire contract should be completed within a period of 15 days? What if the nature of goods concerned is perishable goods? So in that case, should we rely on this 30 days notice, or there should be something else? Now, Anirudh shall deal with public utility contracts and other provisions.
Thank you, Sahil, for that wonderful walkthrough of the Act. I'll be dealing with public utility contracts, something Mr. Kapoor has worked extensively on and written extensively in the report itself. Know what are public utility contracts and why were there special niche for it as such has been created in the SRA, and why is it been created as such? So need for special recognition is one, because this recognition stems from the delay in public infrastructure work deprives citizens of the project's utility. And they're looking at that these infrastructure projects as such have been scheduled, such as transport, energy, water, sanitation. This is entire schedule with section 20 combined with 41 HA. I will deal with that later. But this stemming is from that a project's utility has to reach the public, and delay would actually cause the public being deprived of it, being unnecessary stress on the banking sector as such. This utility should not be delayed by injunctions granted by the court. What are public utility contracts? Again, is for mega structure projects or is as stated above. Moving on, effect of court injunction in public infrastructure projects. There is to be a delay in completion of public infrastructure projects due to court injunctions. They also led to cost overruns. This either result in the public facing inconvenience or deprivation of utility in the project. So if there's a metro work and the court intervened, there would be a delay in the metro work also, but the people could not use the road when they're walking on, and they would neither get the metro nor the road. So that was one of the issues, I think. The resulting injunction also caused unnecessary stress on the banking sector who were heavily invested in this huge infrastructure projects, and they would have to bear the burden of either the company becoming a a company borrowing youth someone to complete projects, but then becoming a non-performing asset due to unnecessary injunctions or lack of understanding by the courts, and creating this disarray in their sector itself. Now, moving on. I have a particular case from the Delhi High Court, which is Ariram Nagar and others versus DDA, which Justice Enlaw, I think, gives a purposive interpretation to the Section 20A of the Specific Relief Act. Here, the particular case is pretty simple. The plaintiff had approached the court seeking a permanent injunction against the DDA and the Delhi police as well. Seeking that they should not interfere in his peaceful possession of the property. The court was apprised that the acquisition of the property was for a development project, and the court recognized it was an infrastructure project under Specific Relief Act. And the court stated a grant of injunction would delay the purpose envisaged by the Specific Relief Amendment Act, even if there's a lack of contractual relationship here. because by granting the injunction, there would be a delay in acquisition of land by the government for a purposive project which is a contractor was already engaged. And they said the purposive interpretation has to be applied here, and hence refused to grant the said injunction in the particular case. Now, moving on, I have a brief overview of the recommendations made by the expert committee and the amendments as such. Uh, Time limit, something as envisaged and recommended on the lines of Art 29A of the Arbitration Conciliation Act, was seen as Section 20C in the Amendment Act, and they gave the same 12-month period, but a 6 additional month if the need arises. The expert appointment, technical assistance if needed, but in a fast but complex contracting world, has been seen as Amendment 14A in the Enabling Court. Special Court, Kelkar Committee report has been referred to in the expert committee report, where they ask for a infrastructure adjudication tribunal, Section 20B. Parliament has said that we'll create an infrastructure court itself, designating special courts. And for infrastructure projects, courts should be mindful in granting injunctive relief. Section 20A, read with 41HA of the SRA, make sure that injunctions are usually not given. So in conclusion, there is the Act ensures that specific performance is the norm, and expert evidence as an aid for better informed judicial intervention is given to the court. There is a need for performance by substitution, which has been recognized, and they've also carved out a niche area for public utility contracts, which is a great way to ensure public get the set deliverables as envisaged by the government in a welfare state. Thank you so much. If anybody wants to reach out to us, they can reach out to us this email IDs. But I do have a few questions which the committee and ourselves can ponder upon. The promisee entitled to claim interim relief in case of a substituted performance. Will a party be entitled to substituted performance in case there is a bar in terms of Section 11, 14 BC, Section BC of the Act? And that is all from us. And thank you. I will hand over to the moderator. Thank you so much, Mayor.
Thank you very much. That was a very nice overview, and I would like to thank you very much. So, and that actually sets the stage for us to go deeper into these issues. And in fact, one thing in the presentation I noted was also you highlighted some areas of where the expert committee had recommended something, but the Act may not have acted on the expert committee recommendation fully. And I'm sure we'll hear more of that from both Professor Bhatbade and Mr. Kapoor, because both of them were, of course, on the committee. And you've also raised a very interesting question at the end about interim relief and whether the law relating to interim reliefs will be affected by the amendments. And that is also something which perhaps Senior Advocate Shri Raghuram could touch upon in his presentation. So what I would suggest is that we now proceed to the panelists and have their views on certain specific aspects which they will be going into. And perhaps once we've gotten those views, taken those views on board, we can perhaps dig deeper and initiate a discussion, an open discussion, because I think this is a unique opportunity for all of us. We have two members of the expert panel, both of them also experts in contract law, and we have a very senior litigator who does this in and out of court every day. He's a senior advocate, and so we have a good chance to clarify several doubts and maybe come up with some interesting discussions. So may I now request Professor Bhatbade, if because she's going to go a little bit deeper into the primary aspect of damages no longer being the main remedy, so to say. So may I request Professor Bhatbade, please, and then we can go through the speakers, the panelists, and then we'll open up for discussion if that works. Professor Bhatbade, over to you.
I think I'll be able to present. First of all, Mihir and Mahesh, can you hear me well?
Perfect.
Yes, perfect.
Very good. I'll just start my presentation. Let me see. I have not used Zoom before. So I select and then share. Are you able to see my presentation?
Yes.
Good. It is wonderful to join the conclave and speak about this theme. It is a very complex subject and understood very well by practitioners affecting litigants because it is essentially a topic of procedure. I did a lot of research in order to arrive at a conclusion that was a subject of my PhD thesis. Ultimately, it became a book, and found that when Indian courts have decided matters, they rarely applied the inadequacy test. And then came to a conclusion that even without the inadequacy test, we will be very well off. Later, I had this occasion to be on the committee, and I'm glad that the Daksha Fellows have gone in detail through the reports of the committee, of which Mr. Amit Kapoor was also a very senior member and contributed his expertise in terms of infrastructure projects. Now, my theme today for discussion is that no longer it is an exceptional remedy. And if time permits, I will also answer the two questions about substituted performance which were asked. Please excuse me for using what I call is the electronic version of the blackboard, right? Instead of a blackboard in the class, I prefer to use this MS Word so that I'm able to highlight or to add anything into it. Now, before the amendment, this is how Section 10 stood. And firstly, it said that the contract may be enforced. And this is where we call the first part of the inadequacy test. Compensation cannot be ascertained. It is unascertainable. So it's such a unique thing that you cannot calculate what is the loss. And the second is where even if it is granted, it will be inadequate. So it is something special, something not available in the market, etc. And these two together, that compensation cannot be ascertained, or compensation, even if ascertainable, will not be adequate. This I call the inadequacy test. And it is indeed the first hurdle which a plaintiff must encounter before he seeks specific performance. Then there were two presumptions. And this presumption, where there is a contract of immovable property, it will be presumed that compensation is inadequate. This is why most case law relating to specific performance, all aspects of specific performance, most of it, if I put all the judgments in percentage terms, 98% of the judgments are about immovable property, because people who wanted to enforce, plaintiffs who wanted to enforce contracts for transfer of immovable property were confident in asking for that relief. Whereas, if it was a contract to transfer movable property, which is clause number 2, then the plaintiff had to show that it was not an ordinary article of commerce. It's not usually sold. It is of special value or interest to me. For example, it is a unique item which once belonged to my great-grandfather. So to me, it is valuable, but may not be to others. Or it's not easily available in the market. For example, that would include what we call the entire production purchases and so on. And it was in these conditions that a plaintiff could obtain specific performance. Now, what has happened in 2018? It has become a simple provision that specific performance shall be enforced. And the only limits on that enforcement are those given in Section 11, Section 14, and Section 16. Because I'm not dealing with it, let me just talk about 14 and 16. 11 is about trusts. I will leave it aside. But Section 14 says that even where specific performance is asked for, it is important that the court should be able to actually execute the order to the satisfaction of the plaintiff. And if that is not possible, then naturally the court should not grant specific performance, simply because its incapability to enforce it. And Section 16 had to do with, or has to do with, the personal qualities or the I would say personal aspects of the plaintiff. For example, that he should be ready and willing, he should not be violating any essential term, and so on. And the very important Section 20 at that time, which relates to discretion, has been totally removed. This is an aspect, I'm sure, which Mr. Sri, just a minute. Mr. Sri Raghuram. I'm sure he will have a lot to speak about this. This is affecting so many contracts and so much of litigation relating to specific performance. Now, we must remember, although the amendment was made, with a view to ease the doing of business in India. The law which is made affects as much business transactions as it affects common people like you and me who make contracts for purchase of property, for purchase of items, and so on. So, the focus of the amendment is, of course, business should be made easy, but its effect lies equally on contracts made by common people like us. And this is something which I'm sure advocates have to bear in mind. And I'm sure they see the effect of this amendment in a very different way when you apply it to common people. Now, I come to the focus of my presentation today, and that is the inadequacy test. I've spoken about this. Specific performance is possible only if compensation is unascertainable or inadequate test. It is a threshold test. And by putting this test, the law in the legal system preempted the promisee's choice. So if the promisee wanted specific performance, the legal system put what do you call it, a hurdle, that you cross this hurdle and then only you will get specific performance. And this was the hurdle. There are umpteen justifications for this, including based on economic analysis. That first of all, it has a historical justification because there are two distinct remedies, common law remedies and equitable remedies. The second is the concerns of liberty, that a defendant against whom an order is passed, he has that right of liberty, as we call it, the liberty. And if you force him to do something, well, that is not desirable. And the third and the more important part is an aspect where litigation is discouraged. What is it? That if substitutes are available, let the plaintiff go and obtain those substitutes. Remember, that is the inadequacy test. Substitute is available, so compensation is adequate. That actually essentially is the what I call the real reason behind the inadequacy test. And believe me, that the fact that substitutes will be available or they are available is a bar to the grant of specific performance, even in those countries where specific performance is a general remedy. So go obtain your substitutes, get your contract performed, and claim the amount. Why are you asking the court to enforce exactly the promise? This is the idea, and I will come back to this a bit later. So what is the effect of this amendment? The effect of the inadequacy test is that granting of relief was uncertain. I may file a suit, but I'm not sure whether the court will hold that compensation is inadequate or not. The second aspect which increased the uncertainty was the discretion which courts exercised. And I'm not dealing with it, but it's a very important part of the amendment. All those factors based on which discretion could be exercised by the courts, the committee recommended that most of those factors should be incorporated as defenses. So those factors can still be shown, but they will not remain court's discretion, but they will be proved by the defendant. However, this aspect, this part of the recommendation was not accepted. The other effect of the inadequacy test is that the burden of proof is on the plaintiff, who is the victim of the breach. He does, of course, have to show that he has a contract, that it is broken, or in specific performance language, the defendant has refused to perform it. And therefore, plus compensation is inadequate, right? And therefore, that is a hurdle. Instead of this now, the amendment has shifted the burden and made it easier for the plaintiff. So in terms of evidence, it is now easier. Now, what is the change? The change is that the remedy has become a general remedy. The promisee can choose. He who wants to enforce the promise, he can choose whether he wants compensation, whether he wants substituted performance, or whether he wants specific performance. And the theory, or rather the whole idea, which started my research, came from a very important article by Alan Schwartz. And I will request you all to read it. It is available on the internet, through the internet. It's called A Case for Specific Performance, written in 1979, quoted in every article relating to specific performance across the world. And all he said was, let the promisee choose. Let him decide what is good, and therefore remove the inadequacy test. Now, why should a promisee choose? He has all the information about the transaction, about the business, and the other party, whether the other party will perform or not or will run away. He knows better than the court. Can the other party perform? Should I ask for specific performance? Will he be able to perform? Can he wait till the final decision and decree and its execution? If he wants specific performance, he has to wait until the decree is passed. Is he willing to wait for it? Will the defendant obey the decree? Will it be difficult to enforce against him? Will there be other difficulties in enforcing or executing the decree? Can he bear the cost of litigation and the waiting? So let the plaintiff make this choice and decide whether he wants specific performance or not. And if you look at all these things, then you will conclude, we all will conclude, that the plaintiff will choose specific performance in those very cases where specific performance would have been granted under the earlier regime. He would prefer to get the work done and claim compensation. He would prefer to ask for specific performance only if he can wait. Now, why do we have this? This amendment is because faith in contracting system depends on the enforcement scenario. Can contracts be enforced? This is one aspect based on which parties will have faith in their own contracts. And the second aspect which governs faith in contracting is the regime of remedies. The regime of remedies should be such that it encourages performance. People should feel that they should perform because the other party has a remedy. It discourages breach. Even if they want to break, they will think twice before breaking because there is a remedy. And because litigation should not be encouraged, any remedy should be such that it should also encourage a settlement in cases of disputes. So, faith in contracting system also depends on performance culture. Are people willing to perform in this legal system is also one more factor. And it is expected that this change is likely to improve the performance of contracts and therefore faith in contracting. Now, when specific performance is available generally, and this is what many academics have stated, it will allow enforcement, it will deter breaches, it will improve faith in contracts, and all that the plaintiff must prove is the contract and the breach. Now I come to this aspect, are substitutes available? This specific performance is actually two parts. One is, if you have agreed to deliver goods, then I want those goods. So this is the benefit under the contract. And the second part is it important that you should be delivering to them? So who should perform? Should the defendant perform? Is it important that the defendant should perform? And therefore, if I take only the first part and I say, if it's the goods I want, let me go into the market and buy them, which means I'm asking for a substitute. So if there are substitutes, then the earlier regime said, go and get the substitutes. This is the inadequacy test. Do not wait for the defendant to perform. Now, when substitutes are available, the plaintiff can choose to get the work and claim the amount. If substitutes are available, this remedy is available to him, the remedy of substituted performance under the new section 20. And he can get it performed through a third party and claim. And should the promisee force to get the substitute, the committee had made a recommendation that if substitutes are available, then specific performance ought not to be granted. And this was incorporated into section amendment as a proposed amendment to section 14, but this has not been accepted. So all over the world, in all regimes where specific performance criteria are laid down for grant of remedy, the availability of substitute bars the remedy. However, that is not the case in Indian law because this aspect has not been brought as a defense in the suit for specific performance. Now, although specific performance can be asked for by anybody, there are still issues of enforcement. What is this? If you make a singer sing, if you compel a singer to sing, then two things can happen. Number one, a recalcitrant singer will not put up the best performance. And number two, because of the differences between the parties, even if the singer puts in the best performance, the other party will not be happy with it. So enforcing the performance may not satisfy the plaintiff fully. The other is where there are other angles to it which I will deal. Section 14, even the current one under the amendment and even before the amendment, deals with these types of cases. Yes, the contract is specifically enforceable, but the court will not grant it if it cannot be enforced. And certain criteria were given. Personal contracts was one such criteria. So, our question in enforcement is, can the decree be effectively executed? In the sense that, can you really effectively compel the defendant to perform? Second, does the court have the ability to enforce? For example, if constant supervision is required for a building, is it possible for a court or somebody from the court to go and supervise that building to see whether it is being done according to the contract or not? And what about costs of enforcement, where you involve the court to judge the performance, whether it's according to the contract or not? What about the cost of the court's time? These are the concerns. And if you take a look at the provisions of Section 14, you will see that these are the concerns which it addresses. My issue, which I think we must look at, is that now that it is understood that arbitrators can grant specific performance, the whole question is that let us suppose that an arbitrator makes an award of specific performance. It ultimately comes to the court to enforce. And what if the court is unable to enforce it? What happens to the award? So this is an issue which probably we will have to grapple over time. Now, one more aspect we remember, and this comes from this I have added after I saw the presentation, that all these remedies under the Specific Relief Act and the main remedy under the Contract Act, whether it's compensation, specific performance, substituted performance, or injunction, where you require it for enforcing contracts, all these remedies, it is for the party to choose it. It is for the plaintiff to choose. So the plaintiff can choose specific performance, or he can choose substituted performance, or he can choose simply compensation, where he can make a claim even without or before incurring the actual loss. How he chooses the remedy, he has to look at the regime of that remedy and choose it. And the other aspect which I wish to stress is that given this regime of remedies, it is possible for parties to provide in their contract what they choose as a remedy or what they restrict as a remedy. So it is very fine for parties to provide that parties cannot obtain specific performance, or parties will not be entitled to substituted performance, or parties will only be entitled to that is risk and cost clauses. So parties can choose their remedies, whatever the nature of the regime in the contract law. I come to two questions. Is it okay, Mihir, if I answer these two questions which were raised about substituted performance?
Of course.
Yeah.
Please.
One question is that can there be interim relief in respect of substituted performance? Now, the main idea of substituted performance, as the section was made by the committee, drafted by the committee, as well as it is drafted or as it has come in the amendment, is that the plaintiff should get the whole work done and then only he can claim. Now, if he does not wish to do that, he still has a remedy under Section 73 that is not barred. So he can simply create an account saying, these are the likely expenses, give me that loss. Because one of the principles of contract law is that you need not actually have suffered the loss before you claim it. So that remedy is still open to him. The second question is about reference to substituted performance in a number of sections. Actually, I believe that incorporating all reference of substituted performance in different sections, for example, in 14, and again another section in Section 20, a subsection in the new Section 20, I think it is a bad copy-paste job made in the amendment. I believe that Section 14 should have said that specific performance will not be granted if substitutes are available. But instead of that, it says if party asks for substituted performance, he can't claim specific performance. This is actually, I believe, is redundant, because if you ask for specific performance, you're asking for performance in the future. Excuse me. If you ask for substituted performance, you've already got the work done. There can be additional compensation, for example, compensation for the delay, which is not barred by Section 20. But once you ask for substituted performance, there is nothing remaining for performance to be done. And therefore, I do not think that the addition in Section 11 or Section 14 relating to substituted performance is really very relevant. Thank you very much.
Thank you, Professor Bhatbade. It's always a treat to listen to Professor Bhatbade. We will have some questions for Professor Bhatbade and the other panelists, but I think we will come back to those questions in just a bit. I noticed that in the chat window there is a very interesting question raised, so I'll just flag the question for now. If a specific relief litigation case is started in 2010, can the new amendment be used, or does it apply to cases beginning from 2018? So what is the date of application of the amendment? Now, in fact, if we were to add to that question, there are at least four possibilities. One, that the amendment applies if contracts are entered into after 2018. Second, contract is entered into prior to 2018, but the breach or the cause of action arises after 2018. Third, that a suit has already been filed and is pending. Finally, a suit may have been filed and decided, and an appeal may be pending saying that no, they should have granted specific performance and not just damages. So there are a multitude of possibilities. And I think we saw similar instances of litigation recently when it came to the Arbitration Act amendments. And purely from the private law angle, this type of question has in fact arisen since at least 1929, because the Transfer of Property Act was amended in the 1920s to insert Section 53A on part performance. And there are a number of High Court judgments which go both ways actually as to whether 53A will apply to contracts prior to 1929 or not. We'll come back to that question in a bit. But one other aspect which I wanted to highlight, which Professor Bhatbade mentioned, was that sometimes we tend to, perhaps I think, draw too great a distinction between civil law and common law jurisdictions. It is not as if, as Professor Bhatbade said, that when they say that specific performance is the primary remedy, it's not as if you can get it for the asking without anything else. And that is something we'll come to again in the discussions. And the element of discretion. Now, before we go to the further panelists, I just wanted to highlight one aspect. Sometimes, to my mind, it seems that the villain, discretion is sometimes thought of to be a villain in the proceedings, that judges should not have discretion. But judges will always have discretion. Even if you look at purely a damages case, remoteness and causation are matters of, there are policy considerations even in those. It is not as if a judge has no discretion, that Hadley versus Baxendale is there and therefore nothing further survives. It's obviously never that case. So discretion is always there with a judge, and sometimes it is good that there is discretion with a judge. But we will come to these aspects in just a bit. May I now request Mr. Kapoor to go deeper into the infrastructural aspects of the amendments and also his experience and thoughts on how the committee's work has been translated into the Act. And well, Professor Bhatbade has made some of her views quite plain in that regard. Whether Mr. Kapoor shares those views, that is another thing which I'm very keen to know. Mr. Kapoor.
Thank you. It's a pleasure being here today. It was indeed a very interesting 4 or 5 months we spent in deep discussions, and Professor Bhatbade contributed a lot in helping us think through the conceptual concepts. So it's a pleasure to see her again after a long time. But as far as the infrastructure issue is concerned, I think the entire underlying thought was in context of the fact that there were a series of judgments which are quoted in the committee report. And if you don't have it handy and you would like to for academic interest, I'm happy to send you the citations, where repeatedly Supreme Court of India had lamented the adverse effect on public interest and welfare due to delays caused by pending matters in courts, particularly on infrastructure projects. And there were projects in which the delays were on account of a couple of plot holders blocking construction of a highway or an expressway for 20 and 25 years. Now, in those situations, the court did realize, and it actually says, that hundreds of times of the cost enhancement has gone through. So the issue that came up was that unlike the private commodities and the private goods, inherently these infrastructure projects are public goods. They are public goods for various factors. One amongst them is the fact that they are meant for consumption by the public. It's an input to the citizen, input to the economy, be it agriculture, industry, commerce, just a citizen's life. Number two, it involves invariably debt financing for long term and comes on the grant of a concession from the government or the sovereign, whether you are allocating natural resources like coal mine, spectrum, land, other consents and concessions without which the private sector or the joint venture partners could not have taken up the project. And in that light, the question was that does it answer the need of Article 39? Something that had bothered me all along and I brought to bear in the discussions and fortunately found resonance in the team was that often enough in disputes involving infrastructure, somewhere we lose sight of, to my mind, the foundational principle of economic governance in the country, which is Article 39. The Directive Principle of State Policy quite clearly lays out how all instrumentalities of state must behave when it comes to issues of allocation and allocative decisions, not to allow monopolization and exploitation, ensure maximum welfare. Now, the question is, how does welfare get achieved if you and I in a private dispute are able to block out the facility in which you are sitting today for a few years? Let us say I have a construction contract. And out of that construction contract, I am able to come and take an injunction and seal off the facility in which you are sitting today, interacting over the next 3 days and learning from various practitioners and experts, besides running your classroom. Whose benefit does it accrue to? And that question, unlike an open market commodity where you have multiplicity of providers, unlike infrastructure where you have monopolies, poses the question as to whether it is in the ilk of welfare that you would try and permit a routine injunction by the slave of hand. Interesting, that's the exact term that Justice Enloy used in his judgment. He said that when the landholder was asked as to can he demonstrate that this land is owned by him so as to seek the injunction that he seeks, the counsel by a slave of hand suggested that it's actually for the defendant to discharge that duty. And he said, sorry, we can't take claim for injunction against infrastructure so lightly. Incidentally, even in the Central Vista project at para 563, the Supreme Court draws strength from the fact that there is a section 20 capital A of the Specific Relief Act. And so this is now gradually coming into jurisprudence. Many of us may not agree with what came out of the Central Vista project in the judgment. But the fact of the matter is that infrastructure projects as public goods now stand classified as a separate category from the open market commodities which are available in terms of consumer choice, options, and multiplicity versus a monopoly scenario. So that's the broad thematic underlying principle. So I thought that I will first touch upon why this classification came by, and I'm happy to share the research which went into the report because of which this came out. Coming to the question that was posed to me by the chair, Mihir, that are everything kosher in terms of what was done? Well, there are provisions that were proposed by us in the committee, which were with certain changes recommended by the Ministry of Law, but ultimately what came to the Parliament and came to be enacted was different. For example, there was a proviso proposed to what exists as Section 20A1 today, which proviso did acknowledge that in extraordinary circumstances, the court may grant injunction, but the injunction will be subject to various terms and limitations in terms of time. In fact, the exact language, if I may read from what was tabled to what was proposed to what came out, the provision actually, the proviso read, and I took it out so that I could place it, yes. So if you have Section 20A, then the proviso after that one, provided that in cases where injunction is granted, the court shall, as far as practicable, ensure continued provision of the relevant service, being the subject matter of such contract, subject to such terms and conditions as it may deem fit. Now, this was what was proposed by the Ministry of Law based on our recommendation, but this is not what found its way into the legislation. And as you know, legislative process has its own meandering path as they go forward. So there were obviously things which were weighed and perhaps The notion was that the discretion would be clipped, as has been already noticed by the chair, that discretion cannot be wished away completely. You can put it to terms in terms of a higher standard. You can require that the consideration be keeping in mind Article 39 principles. But to say that court can under no circumstances grant an injunction may be a difficult one. For example, consider this, that it is evident that a particular flyover over a river or a bridge over a river is collapsing. And a citizen approaches the court asking for a blocking of that and not to be permitted to be used. Would the court sit by and say that let people travel over it and fall into the river to death and injury, but not injunct? I don't know. Take another instance. If there is a nuclear power plant which has an ongoing reaction and a threat to public life, shutting down the plant versus continuing. So there are various questions that will come up as they go along. And therefore, there is a need, and a very important need, for us to always retain judicial discretion, because the man on the spot alone can decide what is to be done. And at times, these challenges do come up as we go along. So that was one area where I thought that perhaps not granting the proviso will at some stage lead to a reading of the proviso into the act, because ex debito justitia, whether you like it or not, under 226 and 32, and under 136, the superior courts, whether it be a writ court in the High Court or the Supreme Court, are definitely empowered and at times mandated and required to intervene if there is a challenge. I would stop here unless there are specifics that you would want to know. And of course, the correlate of 20A is the 20B and C, where when you take it out of the civil court, the construct was that special courts should be appointed. I don't think the special courts have been appointed, and there is a challenge in terms of special courts getting appointed. The idea was that when you're looking at complex contracts of the nature that we are looking at, where there may be engineering issues, there may be challenging issues of science and technology, there may be public finance and policy issues, the courts must be specialized. They must focus on fast track, not be burdened with a roster which has multiple things going, not what we have seen of Negotiable Instruments Act, for example. And the idea was that they develop expertise and also are able to call for expert testimony to try and adjudicate matters which are of gravity and which can affect public welfare and public interest significantly. Another area which weighed very heavily was the fact that even today, 60 to 70%, if not more, of the non-performing assets of the country are basically, which is your banking sector's crisis today, are all tied into infrastructure. So there is a need for us to understand that delays can be a challenge. And there I will leave one thought with you before I close. And that thought is that the underlying principle of contract enforcement originated on a pay and get out or buy your way out of a contract in 1800s. From there, we moved to the amendment of 1963, where the new act came in, where we provided for specific performance as an alternate. And today you have a complete switch where specific performance is actually the principle. So, and it has brought in, borrowed from the experiences of civil law. These are interesting developments which are going to be of critical importance. The significant issue that is that in India, please don't forget, the cost of capital and financing, in spite of the COVID time break and take it away, is anything from 12 to 14% for the best of the corporates. 12 to 14% per annum. If you have a 2 or 3 year delay in the capital cost of a project, you have made sure that in spite of a 25-year cycle in a price sensitive economy, the project is bound to not be able to sustain and earn the returns. So the criticality of timely implementation, the criticality of making sure that when infrastructure is created, whether it is water supply, sewage treatment, roads, highways, airports, ports, etc., you must have full use of the asset, because the asset has been created with public finance for public consumption in the interest of the citizen. And that is the gravamen of the basic provision. I will stop here unless there are questions that you would want me to answer.
Thank you very much, Mr. Kapoor. We will have questions. I think some of the students and the fellows also may want further questions, but we'll just come to those in a bit. I wanted to particularly thank you for approaching this issue from the perspective of Article 39 as well, because that gives a sort of a grounding to understanding why these amendments are there. And just to the point which you ended up with, part of one school of thought, as you put it, was the school of efficient breach of contract, so to say, that I pay my way out of it. What's the problem for anybody? But as you pointed out, the problem is that there are going to be transaction costs associated. I mean, markets are not efficient. There are going to be transaction costs, delays in court to get that money. Then there are going to be several factors which indicate a need for moving towards the paradigm of specific performance. At the same time, as you pointed out, you can't do away with discretion entirely. One could say that perhaps having discretion in the statute at least makes people aware that this discretion does exist, rather than courts having to, in a sense, courts at some point, when the facts are glaring, courts will read down the provision, and that is bound to lead to less certainty. On second down, I think there are lots of interesting issues from a litigator's perspective. How should a litigator go about thinking about these amendments? How should those amendments come into actual cases? And to help throw light on some of those issues, may I please request Senior Advocate Sri Raghuram to address us on those aspects.
Good afternoon to all the panelists and the students. I had the benefit of hearing the academic speech of Professor Nilmaji and the benefit of hearing Mr. Kapoor's experienced infrastructure legal perspective. And he also being the member of the committee, we had the advantage of his perspective. I have a viewpoint of a pure litigation lawyer, so I would like to contribute in that fashion. In fact, a lawyer, in one context, when I was arguing a case of Hyderabad Cricket Association in a subject of conflict of interest, there was an interesting statement that a conflict of interest is a kind of a situation. A bias is a perception, and advocacy is a kind of prejudice. So when I address, I would take one stand. So that would be beneficial because I would be addressing the gathering with my perspective of in one particular, if you call it as a prejudice, that I would take a stand. Having heard the student presentation and also the learned presentation of the amendments by the professor, what I see from the statements and objects which are necessary to appreciate the requirement of an amendment, applying the rule of mischief as an interpretation of statutes, what was that the amendment was trying to achieve? From the statement objects, if we gather, there are two things. They were trying to remove what they thought was a discretion which was coming in the way of the implementation of the specific relief, performance relief, and also to expedite the relief or the dispute resolution. So these two were the objects, it appears from the statement of and objects of the amendment and the committee's recommendation also. Have the amendments have really addressed these two aspects, and has it resulted in resolution of these what you call, say, hurdles? I would say that to the extent of resolution of problems of a class, namely the industrial and commercial litigation, I think they have addressed it very adequately. But there is another class which regularly go to court, with whom I have been for the past almost 40 years dealing with. They are also common man who deals with the contracts. There are contracts in the life of almost every citizen of the country. In fact, there are contracts. Without these contracts, the common man cannot really advance his day-to-day life. So that part, I would say that the amendments have really not considered their travels in the dispute resolution or their rights. I'll come back to that, which would be my argument. But I have to deal with the positive side of these amendments, that is its effect on the infrastructure industry and the commercialization of the country and taking it forward. And there shall not be any hurdles due to the litigation. That far is concerned, I think it has taken very positive steps. I can give some examples of my own experience in this field. I'm now presently dealing with one example to be very apt. I'm dealing with one case which is a development of port facility. I will not give the names, but the issue was that a contract was given. It's called a concession agreement, which is a contract which has been drafted by the Planning Commission, which has a PPP mode to be executed by a global contract. They were to set up a facility for the export and import of a particular kind of goods at the port area. The contract was for a period of 2 years. The contractor took possession, did not complete the contract, and has spent more than what the contracted value was. End of the day, he has finished just at the end of 2 years, finished just 60% of the contract. And he was going on. By the time 2 years ended, he has exhausted his finances. The situation was the contract contemplates consultation procedure to rectify the mistakes or the breaches committed. They took 1.5 years for consultation period. Ultimately, they have no option but to terminate the contract. The contract was closed in 2016. It was almost abandoned in 2016. Arbitration started in 2019. We are in 2021, but the facility is lying like that. So in that context, the amendment to Section 20 of substituted facility is of a great help. Now, kindly see the way the litigants approach. The contractor who has raised the claim challenges the termination on saying that termination is illegal, but he would not want specific performance because he has no funds. So only option the employer has is to have a substituted execution of the contract performance. That was not available to us when actually the conflict has started. So in that context, why I gave that example, it's an ideal case where substituted performance is the remedy. And in this context, I can also answer one of the questions raised by the students with regard to the substituted service can be taken as an interim order. Well, interim order is preservation of rights of the parties pending the finalization of litigation. When substituted performance is required, it is actually required to mitigate the situation. If we are not in a position to get the interim relief as substituted performance, it would be taken only at the end of the resolution of the dispute. It is of no use almost. So I would say that if we are able to satisfy the court on the conditions for granting an interim order, that is a prima facie case, balance of convenience and public interest, there is a very good case for grant of interim order. I think it's a matter for good for an interim order as far as substituted performance is concerned. So I would congratulate the committee and also the amendments I approve. So far as this section of the classification Mr. Kapoor also made with regard to the infrastructure industry and the commercial contracts. And also only one thing I have to add as far as second part of is concerned. So removal of discretion is helping the infrastructure industry for the resolution of the disputes and the quick performance. Because performance has become a right. We have now traveled from contract status to again going back to contract. So the specific performance has become now a right under the Act. In fact, as the several authors speak of performance specific performance was never a right. In fact, Fry on specific performance quotes a kind of a position where in ancient systems, none other than India, the enforcement of a contract was never considered to be a right, because they said that nobody should enter into contract if it is not enforceable. So that was the kind of approach certain societies were having. In fact, in India, that was the position. So now, in view of these developments, commercialization and all, performance is a right to the section of industrial and commercial groups is absolutely necessary, and it is can be recommended. And discretion to that extent is removed is also is manageable is my take. But the second part is that if it comes to a common man dealing with smaller areas, smaller sections of rather values. For instance, suppose he's dealing with an agriculture land, say of 1 acre or 2 acres. You all know there's the lower class and the lower economic classes and the middle classes depend on small extents of land as their asset for lifetime. These assets are used for every event of their life, for education of their children, for the marriage of the daughter, for health reasons. So when they have an asset, they have to enter into a contract to sell their property. When apply these now the amended sections, more particularly section 20, if an unscrupulous purchaser gets into a litigation, what are the defenses for the seller? What are the vendor's defenses in that case? Earlier scenario, when section 20 was there, we had several defenses such as even the conduct of the claimant, delay in latches, hardship, misdescription of the subject matter, adequacy of consideration. So these are the defenses he could have taken. In fact, I would also quote one of my experiences, a pending case. I'm appearing for rather a father and mother, both who are holding a property of about 500 square yards in a city. They wanted to dispose of their property so that their son can establish his business. They entered into an agreement of sale. This is about 10 years back. The amount was to be paid within 15 days. The purchaser paid 10% of the amount, never paid the rest of the amount. But after 15 days, giving some false notice, he has filed a suit for specific performance. And since the agreement was correct, the defense was that we have hardship. Now the suit was coming for hearing after 4 years. So there is a hardship. I can't sell this property at this stage, and the reason for my sale has long been lost because my son's businesses could not establish it. So that particular defense was not accepted by the trial court, and the suit was decreed. Now it is an appeal. Unfortunately, appeal has now entered the 7th year. So at this stage, after the section 20 is removed, I don't think I would succeed in my appeal. I lose the case. So this is the situation as far as the other part of the class of the people are concerned. Smaller extents, people who depend on these properties as their lifetime assets. So these are the difficulties which will have. The defenses are almost removed when it comes to the vendors. So this is my take as far as the amendments are concerned. Then the second part, or I'll just conclude another point on the discretion. The idea of discretion being equivalent to equity, I think, was not a clear jurisprudential point which the legislature has considered. Merely by removing the discretion, you can't say that equity is totally removed. Lawyers like me can argue that even if you remove section 20, in a civil court, I'll always appeal to section 151 of CPC, the inherent powers of the court, and appeal to the court with regard to equity. Court can always mold the relief under section 151 and give me relief. So I'm going to argue that 151 gives me the discretion which is available under Section 20, which is removed now. So the legislature should have been a little bit more discreet in removing 20 altogether, uh, and should have made a classification. They could have made a classification very categorically so far as the infrastructure and development commercial contracts are concerned, as in the case of a commercial disputes. The yeah, disputes. I'm sorry, I think I'm exceeding time. 2 minutes, I'll close.
No, I think we have time, sir. Please.
So that part, commercial contracts are concerned, they can be one classification. The rest of the people dealing with the normal contracts should not have been subject to these amendments, especially when there is a removal of total defenses which a vendor can take from the point of the vendor. Then the last point is whether the expediting the matter. Only thing which has been brought in with amendment is Section 20B, I think, is where time limits are given. My experience is the courts merely fixing some time at the trial court, saying that 2 years the matter has to be disposed of. I'm watching the arbitrations. Every arbitration is going beyond 2.5 years. Almost even yesterday we filed an extension petition 29A for another case. So every arbitration goes beyond 2.5 years. But arbitration is 2.5 years. After that, Section 34 application has its own time. Then we go to the commercial courts. Here in Hyderabad, we have High Court. So the hierarchy of courts ultimately takes not 2 years, it's a multiplication of 2. It will go to 8 or 10 years. So fixing time only at the trial court level is not is sufficient for a expeditious disposal. They ought to have fixed it with up to the levels. They should have given a finality to this dispute, at least to the appellate stage, and fixing some time. That would have been an easier way of dispute resolution. So the time factor also, I thought, was not very well addressed. So these are my takes on the amendments. So I'll be ready for any questions, which is my ball game. I can answer any questions. Back to you.
Thank you very much, sir. I think we have one question which we can, to start off the discussion, I think perhaps if you could consider this question in the chat. The question is, do you think with the insertion of Section 20C of the Act, where disposal of time, a consequential amendment should have also been made to Article 54 of the Limitation Act? Because I think the point which is being made is that you can wait for 3 years and then come to court and say, I want specific performance now. Sorry, court has no discretion because delay is not a bar anymore, no latches.
I think it's a brilliant question. In fact, I think I missed a point I wanted to address. In fact, the Article 54, 3 years from the date of breach, there are cases which I have argued after 20 years. I argued for a plaintiff and succeeded because the time starts running from the date of breach, 3 years from the breach. So there is no breach, nobody has communicated, the contract is of even 10 years old, can still be enforced. So therefore, amending 54 by reducing the time at least from 3 years to say 6 years, 6 months, should be very, I think, imminent necessity. And also, as I said, 20B is only at the trial court stage. There should be some other sealing on the appellate court and further remedies.
Thank you very much. I think one very interesting point which emerged was that even Mr. Kapoor was saying that there will be a scope for courts to read down the provision to bring in discretion in reserving cases, and you've provided that hook of Section 151 because the inherent powers. May I just ask if any of the other panelists, Professor Bhattbade or Mr. Kapoor, whether they have any thoughts on, or whether this was part of the committee's consideration as to whether the courts should still be able to exercise their inherent powers or not, whether this was something which was considered by either them or by the legislature?
Shall I? Mr.
Please go
Kapoor,
ahead.
please.
Please go ahead. No, after you,
Please go
Professor.
ahead.
After you. Go ahead,
Yeah,
please.
I'll just share my screen once again. Yes. This is the section 14, which the committee recommended. And I'll very quickly take you through this, but just let me increase the size. Mihir and Mahesh, are you able to see this highlighted portion?
Yes.
Yes, good. So, what the committee recommended is that the court may refuse to grant specific performance where the contract has become incapable of performance, now this whole section 14 has not been taken into consideration. Then where he can obtain substituted performance from another source on comparable terms. This is where the committee recommended that if substitutes are available, let me put on my video too. Let me just check, please. Yes, good. Yes. Then this part, it runs into minute details, etc. It remains. This also remains as it is. Now let me come to the part which talks about discretion, and this is where it starts. Whatever gave the court discretion, that was incorporated into section 14 so that it became a factor to be proved by the defendant rather than remain in the discretion of the court. So, where the terms of the contract at the time of entering into the contract are such that they give an unfair advantage, borrowed from the original section 20, where the performance of the court would involve some hardship which was not foreseeable, again borrowed from 20, and where the contract expressly restricts the right of the plaintiff to such relief. So where the contract itself says that the right is to claim compensation or the right is to claim risk and cost clause, then naturally specific performance ought not to be asked and ought not to be granted. And then in the explanation, we recommended that mere inadequacy of consideration does not amount to undue hardship. And then this was the part where we said that an injunction will not be granted if it would impede or delay the progress. Then this part which says that the building or a work can be ordered to be specifically performed, it is sad that this part is removed because under the current provision as it exists, a contract that the other party should construct will not be enforced because it will involve constant supervision. It could be enforced under the earlier provisions and there were orders of such enforcement because of this exception, but this has been removed. And there is also another part where anything which happens after the making of the contract will not be considered by the court except these. For example, the fact that prices have risen and so on will not be considered. Now, all these exceptions to the grant of relief or similar exceptions you find in all jurisdictions. And we expected, or I expected, that these would get incorporated into the Act, but they haven't. As regards discretion, I believe that courts or judges would like to exercise it. If they find that there is a justice to be achieved or fairness to be achieved, there are many ways in which discretion can be exercised. So if discretion is totally taken away, then judges will exercise it in the manner they want. You know, we remember the chancellor's foot when it comes to exercise of discretion. And that will lead to a lot of uncertainty. It would also, for example, mean that courts in a particular place will exercise discretion under 151, and other courts might take a view that because discretion is now removed, we cannot exercise it. And therefore, I believe that there has to be an element of discretion, or I would put it in another language, there have to be factors which the defendant can raise under which specific performance will not be granted, but the remedy of compensation can still continue. I would also like to answer a bit later, because let us finish this topic, to answer a bit later about the first question raised in the chat, to which I will come later. Thank you.
Thank you. I think we had a question from Nazir Sheikh. If I think they wanted to ask a question. May I request Nazir Sheikh to ask the question? Because I saw the hand was raised in the chat window.
Would be better if the question can be typed out in the chat box.
That
And it's in webinar mode.
yes, so that will be
Open for everyone to, yeah.
yes. And indeed, if there are any other questions, that as well in the chat window, that would be ideal.
It will be interesting to hear Mr. Kapoor on discussion.
Mr. Kapoor, we'll come to you. Mr. Kapoor, you are, please.
Yes. No, I concur with the view. You know, at the end of the day, you can't possibly have a Excel sheet oriented or a robotic adjudicatory process. The court will have to exercise discretion depending on facts and circumstances of a case. And you can't set it down to a situation where there is no discretion to be exercised. So I'd rather that the discretion is guided, it is regulated in terms of the statute, and left to the wisdom of the court at a given point in time. And that's where I agree with both our co-panelists, Sri Raghuram as well as Professor Bhadvade. There is a need for providing it, because if you hardwire it, it'll make impossible and make for tough, difficult situations. It may also lead to reading down through adjudication, which can often go away from the finesse of a legislative draft and could open floodgates. The second fact is that I completely agree in terms of the question that was raised in the chat box and the answer given by Sri Raghuram, that time-bound decision-making at appellate stage as well. Well, the mandate of this team was limited to looking at the specific relief act and not go to the appellate side. When we raise certain aspects, and there are, what Professor Bhadvade was showing, in the proposal that we sent, there were various elements of discretion and time frame, as well as how do you transition from the regular civil court to the special court, how does it run? All of those were somehow not brought into the legislation, but that's a part of legislative process that we can't go beyond a point. And I think the important thing to always remember is that courts will have to have discretion. They will exercise it at some stage. If we deny a court the right to exercise discretion, perhaps it will travel 2 stages and land up in a writ court or in the Supreme Court before that is done. That doesn't achieve the purpose of time-bound adjudication. It opens up the can again. So there is a delicate balance to be struck, and therefore I agree with that view. There is a question by Alexandra Paul, perhaps a comment. Fork in an eye or one time in your ass, and I guess you should take a survey of the group and find out what's their preference.
I think it's also interesting that we often think that discretion is the enemy of certainty, but sometimes removal of discretion can cause more uncertainty. It's as all of you have said, that if discretion is there and there are parameters on which it is to be exercised, it's probably better for certainty overall than to remove discretion altogether. Professor Bhadvade, you wanted to answer one question as well.
I come to the first question in the chat, which is about coming into force of the amendment and its applicability. It was discussed during the committee, and I mean the majority view, because that was not my view, the majority view was let the amendment take its own course. My view is actually that the law should apply only to contracts which are made after it came into force. And the main reason for that is that parties decide their remedy provisions in their contracts with reference to the remedy regime. So if they know what remedies are available, then they will make a provision accordingly in their contract. They can say that specific performance will be available, or they may say specific performance will not be asked, only compensation will be paid. Because the right to remedies definitely affects the manner in which the contract is made. But that is one part of the issue. The second part is that will courts exercise discretion in matters which are already filed, or will they apply the act and say now we have no discretion? I think the law relating to procedure is quite clear on that aspect, that procedural law will continue to apply unamended to proceedings which are pending unless the law clearly says so. And I'm sure that much case law will be found with reference to application of the amendments to the CPC. There is no harm in exercising discretion, even in matters which are already pending. The other aspect is that substituted performance. Should substituted performance be granted to contracts which were made before the amendment? I will say that perhaps cases which were filed after the amendment will not have asked for substituted performance. But for example, if a party has actually fulfilled the procedure, even though the act was not in force, can he amend his plaint to ask for substituted performance? Because then he need not go to the requirement of contemplation, the two rules of Hadley versus Baxendale. I mean, these issues will come up. But my point is that I wish that the amendment would have clearly stated its applicability. We will probably have now some courts saying that we have no discretion and other courts saying we have them. And we all know that this leads to forum shopping and uncertainty. So I believe that it will be good if some judgment is declared where the coming into force and its applicability is discussed. Thank you.
Thank you very much. I think we are just running out of time now because it's been a very interesting discussion and I wish we could go on for a while, but I'm sure you have the next session of the conclave soon. So I would like to thank the panelists for their very interesting and refreshing perspectives. And may I now hand
University and Daksha Fellowship. Please allow me to thank all of you panelists for taking time out from what is a working busy day to speak to our students and also to explore the issues around this new set of amendments that are still gaining foot in our legal system. We at Daksha believe that there's a need to bridge the gap between academics and practice, and the conclave itself is an effort in that direction. We hope that in future days we can host you, all of you, once again at Daksha and keep engaging with you on more interesting questions. Thank you very much, all of you.
Thank you. Thank you. It was a pleasure being here.
Thanks.